most authoritative evening political show, Hot News. We are coming to you from our studios in Abelinkwe 48 Swanika Street here in Accra. We're live on Facebook at Pan-African Television. We're also live on YouTube at Pan-African Television, as well as 48 African countries. My name is Justice Appiah, but don't forget to join us on Facebook at Pan-African Television. Those of you watching us can share the Facebook Live for other people to also watch tonight's edition of the program. You can join in the conversation by sending in your views, comments, and contributions on our WhatsApp/text line. We'll make a time and read all those out for you. My name is Justice Appiah, and tonight on Hot News, we are looking at the ruling by the Supreme Court. And what did the ruling say? The Supreme Court is saying that the Deputy Speaker can vote and form part of quorum for decision making. And I would want to read a brief of, the ruling. Apart from that, the minority in Parliament has been speaking, including some members of Parliament on the side of a minority, accusing the Supreme Court or accusing the decision of being politically motivated. And that was said by the Member of Parliament for Sagnarigu constituency, Honorable Alhaji A.B.A. Fuseni. Now, let's read a bit of the ruling and listen to what the minority has been saying. So the ruling says the Supreme Court has ruled that a Deputy Speaker of Parliament can be counted during the formation of a quorum for parliamentary decision-making and participation in voting whilst presiding. It continued by saying that private legal practitioner Justice Appiah filed the case against the Attorney General. He had asked the Supreme Court to interpret Article 102 and 104 of the 1992 Constitution and declare the action of Mr. Sewusu as unconstitutional. Now, he also wanted the Supreme Court to declare the whole proceedings in Parliament on November 30, 2021, which led to the passage of the 2022 budget as unconstitutional, insisting the Deputy Speaker should not have counted himself as an MP when he presided over proceedings. However, in defense on behalf of the state, the Attorney General, Godfred Yeboah-Dame, argued that no express provision in the 1992 Constitution stops a Deputy Speaker presiding over proceedings from voting or counting himself as part of MPs present to form the right quorum. He argued that the quorum in Parliament formed under Article 102 is different from the quorum formed under Article 104 of the 1992 Constitution. Now, he says, he stated that the quorum under Article 102 is for the conduct of business in Parliament, and that is why the Article 102 provides that it should be 1/3 of members. Quote, given that Parliament presently is made up of 275 members, the quorum under Article 102 for the conduct of its business is 92 MPs, the AG submitted. According to the AG, based on the clear provision of Article 102, any person presiding, either the Speaker or Deputy Speaker, is precluded from being part of a quorum. Now, on the other hand, the AG believes that the quorum under Article 1041, which deals with the determination of matters through voting in Parliament, requires at least half of all MPs, and such a quorum is not the same as one in Article 102. Mr. Dame contends that unlike Article 102, which precludes a person presiding from being part of the quorum, Article 1042 precludes explicitly the Speaker. Now, the AG therefore holds the position that only the person elected, the Speaker of Parliament, is barred from forming part of the quorum under Article 104 when presiding, and not the Deputy Speakers who preside over proceedings. Continued by saying that the Apex Court, comprising Justice Jones Doche, Nene Amegache, Prof. Ashikoti, Mariama Owusu, Lovelace Johnson, Clemens Homenyunuga, and Emmanuel Kolendi affirmed the argument of the Attorney General. The court also struck out portions of the standing orders of Parliament, which reads, quote, a Deputy Speaker or any other member presiding shall not retain his original vote whilst presiding. But this, the minority in parliament found very bad, extremely bad. They think that the decision was politically motivated. They have been speaking. Let's listen to the minority leader and what he has been saying. We'll be back.
Our attention has just been drawn to a ruling of the Supreme Court on the matter as to whether a person presiding as Speaker, consistent with Article 102 of the 1992 Constitution, which provides for the quorum, and Article 104, can exercise a vote whilst presiding. Our attention has been drawn to a very disappointing ruling of the Supreme Court of Ghana, which more or less amounts to a judicial interference in time-tested parliamentary practice and established conventions everywhere in the world, in civilized democracies, including the United Kingdom. The presiding officer's vote is discounted. So it's not for nothing that Article 102 provides that a person presiding shall have no original nor custom vote. The Supreme Court, to put it aptly, this ruling is judicial support for e-levy, nothing more. Judicial support for e-levy, for a struggling economy in distress, and judicial support for the restoration of a matter that they have said is constitutional, is repugnant to the provisions of Article 102 and 104. But what can we do? They are clothed with the mandate and authority to interpret the law. This is a travesty. This is a travesty of parliamentary justice and a step in the growth and development of multi-party constitutional democracy built on the spirit and principle of checks and balances, of quorum for parliament, for purpose of conducting business. We cannot see any material difference in the provisions of Article 104. But for their purposes, they have said that interpret 102 differently and separately from Article 104. They ought to know that Article 102, even the side notes, marginal note, says quorum of parliament. The judiciary of Ghana is also failing Ghana's parliamentary democracy in their inability to appreciate the true meaning of Article 110 of the Constitution, that Parliament shall by standing orders regulate its own proceedings. When we regulate our own proceedings, and today reference is only made to the 1992 Constitution and not to the standing orders of the Parliament of Ghana, and in particular, Standing Order 13. Today, as we speak, the Speaker is indisposed. There is a presiding person in the first Deputy Speaker. So, for your purposes, can you imagine what will happen in Parliament? While the first Deputy is presiding, there is no second Deputy Speaker available who will preside to supervise him voting for our purposes. It's repugnant and unreasonable decision. He is presiding, so where he is presiding and the second Deputy Speaker for some purposes is not immediately available in the chamber, he will walk down, vote. At that time, there will be no person presiding over the Parliament of Ghana. This is a judicial support for President Nana Addo Dankwa's e-levy that he is laboring to pass. We remain opposed to it stitch by stitch, clause by clause, article by article, when it is presented, we will fight back strongly with our 157 vote. From today, maybe there will be a new definition of who a first or a second deputy speaker is. Maybe they don't deserve us according them the offices they occupy. Maybe that is what the Supreme Court is ruling. We will just recognize them as MP for Fomina and MP for Bekwa.
The minority leader Haruna Idrisu right here addressing the media after the ruling by the Supreme Court. They have described the ruling as a travesty of parliamentary justice as well as a judicial support for President Nana Addo Dankwa Akufo-Addo's e-levy. Is that how you see it? However, the Member of Parliament for Sagnarigu constituency, Honorable Alhaji Abia Husseini, who is the ranking member on the Communications Committee, has also accused the Supreme Court of their decision being politically motivated. Let's listen to him. We'll be right back.
Let me say that this is a very sad day for Ghana's democratic process. That an organ of government tasked with interpreting the law will so hopelessly fail Ghanaians in a matter such as this. This is a clear travesty of justice. It's a very shameful ruling. And I see it as an abuse of power by the judiciary to honestly and faithfully interpret the law. I mean, it's a farcical ruling to all intents and purposes. And I feel so saddened that when you look up to the judiciary to honestly, faithfully, and impartially interpret the law, these are the kind of farcical rulings they come out with. Mr. Speaker, or whoever is presiding, cannot take part in debate. So, even somebody who cannot even take part in debate, how can you vote? You are stopped from taking part in the debate. How can you even vote? And not too long ago, I'm sure Honorable Joe Sewusu himself said that, oh, when it comes to the issue of voting is clear. He does not have a vote. He doesn't retain his original vote. Yet he went to vote. What did he think of us? Fools? We should sit down and look at him, go and vote. So that's why I'm saying that rulings like this, they don't guarantee peace. Because if it happens and he gets up to vote, nobody knows what can happen in the house. Okay? So if the speaker does not take part in debate, how on earth can anybody say that that same speaker who doesn't take part in the vote, in the debate, can go and vote? And let's look at the practicality, the wisdom. That's why I said this is a very poor, politically motivated judgment. If they had increased the depth of impartiality in it, they would have seen that this is not the way to go. Because the framers of the law in their decision, you are presiding over a matter. While you are presiding, you have a duty to be fair, truthful. So if you take part in the vote, where will your fairness lie? And my brother, we are all in this house. When Mr. Speaker, at the end of a motion, the debate on a motion, and Mr. Speaker puts the question, as many as are in favor, say aye. Aye? Is that not what it says? When the members of parliament on the floor are saying aye, will Mr. Speaker say aye? I think article, the earlier parts of the articles between 1 and 3 says that any acts by anybody, and it says anybody, including the judiciary, which is inconsistent with the provisions of the Constitution, to the extent of that inconsistency, is null and void. So if the judiciary is purporting to be doing something that is contrary to the Constitution, that action is null and void. That's an issue. So let nobody run away with the impression that the judiciary can say and do anything they like. They themselves are bound by the law. And if they indulge in an infraction of the law, their action will be considered as null and void. That's an issue. And it is very clear here. I will read it again. A deputy speaker or any other member presiding shall not retain his original vote while presiding. This is the Constitution. The judiciary has no power to set this aside. They have no power. Number two, if you come back, this is in Order 109 of our constitution, of the standing orders of the House. This is the thing that has regulated the conduct of the House for all these years. And it is the same Supreme Court. You see the interesting thing that are coming to catch up with them. It is the same Supreme Court which ruled that Parliament is a master of its own rules. So any rules that Parliament makes to govern the conduct of business in the House is not a subject matter for the court. So those who sent the matter earlier, they told them that they should come back to the House. Parliament is more or less quasi-sovereign. And so Parliament can make rules and regulations to conduct its business. Today they have forgotten of that. Have they forgotten of that ruling of the Supreme Court itself? So you can see that this is a heavily watered political decision just to please the MPP, the Nana Akufo-Addo government in power. The issue of the e-levy. So this is an e-levy judgment. They just ruled to facilitate numbers, to attempt to add some number to the ruling government so that they can pass the e-levy. My brother, before I continue on this tangent, I've said it that Almighty Allah, Almighty God, who created us, today He's made me a member of Parliament. I will stand one day before Him an account. When I was a member of Parliament, how honestly and faithfully did I discharge my duty? So are the judges. He has given them the power of judgment and has enjoined them to be fair, honest, impartial, and truthful. They will stand before their Maker, all of them, in all the judgments they make.
So aside the minority, Center for Democratic Development, CDD, Ghana Fellow on Law and Justice, Professor Kweku Asare, says that Supreme Court cannot tell Parliament how to run its affairs. Now he continued by saying that this is his reaction to a Supreme Court judgment that declared that the Deputy Speaker reserves his voting right despite presiding over parliamentary proceedings. Consider Order 225, which provides that the chairman of a committee shall not have an original vote, but in the event of an equality of votes, he shall give a casting vote. Can the Supreme Court declare the order unconstitutional because it deprives the chairman, therefore his constituents of an original vote? I think not. Nor can the court, in my opinion, invalidate the casting vote because it makes the chairman a sole appellate judge of the committee's decision. In this regard, I agree with Justice Sowa in the oft cited but hardly understood to 4 case when he says that the law and custom of Parliament distinct body of law, and as constitutional experts do put it unknown to the courts, and therefore the courts take judicial notice of what has happened in Parliament. The courts do not and cannot inquire into how Parliament went about its business. Parliament and the courts are co-equal or co-equal branches of government, and neither can tell the other how to run its affairs. If Parliament, in its wisdom and consistent with the rules applicable to the Speaker, decides that a Speaker pro tempore should not take part on debates, vote, or should not caucus with his party or on a matter pending while he presides, it is not for any court to inquire into it, just as it is not for Parliament to inquire into how justices are chosen to sit on cases at the Supreme Court, or why some cases are disposed of with expediency and others seems to disappear into oblivion. Nor am I impressed by the argument that because a speaker pro tempore represents a constituency, it is impermissible for him to be denied a vote while presiding. He goes on and on and on. But what he is actually trying to say is that the court cannot tell, or judiciary cannot tell Parliament how to run its affairs because they are co-equal branches of government. It is getting very, very interesting, and we'll delve deeper into some of these issues on the matter. But they also make their own rules in Parliament. Let's see how all these things, pan out. I've been joined in the studio by a private legal practitioner in person of lawyer Osman Al-Hassan. Lawyer, good evening. Thank you so much for joining us. It's been a long time.
Very long time.
Right.
Good evening to your viewers.
Yes. Also in the studio is Member of Parliament for Drapa constituency in person of Honorable Cletus Seydou Dapila. Honorable, good evening. How are you doing?
Good evening, my brother Justice.
How are the constituents?
Constituents are keeping well.
Right.
I was there over the weekend.
Very well.
And attended some social gatherings and other activities.
Right. So let's move quickly to business, and let me ask you, how has minority taken the ruling by the Supreme Court? Especially, this is an issue that brought about a lot in Parliament. Even, really brought about, fisticuffs, fights, conflicts, and all of that in Parliament. Finally, there has been a finality to that issue over the decision by the Deputy Speaker to vote on the floor of Parliament or to form a quorum. The Supreme Court says, yes, the Deputy Speaker can even form a quorum and vote on issues whilst presiding. How has the minority taken this issue?
Thank you, my brother Justice, once again. Let me say good evening to you, and then good evening to my brother. Let me say good evening to your distinguished viewers.
Right.
Good evening to the good people of Jirapa, the entire globe watching us. Justice, I am worried for our democracy in Ghana, particularly where I sit as a member of Parliament, and the happenings so far in this country. I am not motivated at all about happenings in this country. We have various arms of government. Justice, is not for nothing that we have, these arms of government, and these arms of government are supposed to be a check on the other. That is why we have separation of powers, checks and balances. And I honestly, I'm so disappointed with the ruling. It's so disgusting, as many Ghanaians and independent watchers can confirm or attest to the fact that they are not happy with this ruling. The reality is that you cannot be a referee at the same time a footballer.
Okay.
That is just simply what the Supreme Court did. Justice, I was interacting with the minority chief whip in his office, and I said that if this ruling is anything to go by, that means that a member of Parliament can be a Speaker of Parliament. That's what it means. It means that a member of Parliament can be a Speaker of Parliament.
How would you interpret that?
Yes, I will. Why? What is the reason? The Speaker is supposed to be a neutral person. You understand? That is why the Constitution or the framers of the Constitution have it that the Speaker or a member of Parliament should not be a Speaker. You understand? So that that person can be so independent and cannot be biased. Now, in the absence of the Speaker, we have Deputy Speaker, First Deputy, Second Deputy Speaker. Even with that, in the absence of the two Deputy Speakers, a motion can be tabled to appoint one of the MPs to preside. It is also in our standing orders.
Right.
And the Constitution provides that. Now, if a whole Supreme Court, the bench, the respected bench, will go and take this decision, to achieve what? I'm still so disappointed. I don't know. I can't fathom what they did. What do they think? What do they seek to achieve? Do they still want us to go to the chamber and be fighting? Is that what they want? Is that what they want? Because the Constitution under Article 1110 talks about the fact that Parliament will be regulated by its own standing orders. So you cannot go and try to throw our standing orders to the dogs. When we go to the chamber, we are being regulated, or the House is being governed by our standing orders. And you are an arm of government. You cannot go and throw our standing orders to the dogs. And I just cannot believe what they did. Justice, why will anybody entertain this? Why will anybody entertain this? Look, just last week, the acting chairman of the Judicial Committee, the Honorable Member of Parliament for Salaga, Honorable Abdallah Idi, he presented a statement in the House, and the statement was about it has to do with the judiciary system of this country. You know, how the bottlenecks, how people don't have confidence in our judicial system, and all of that. You see, you are the apex court of the land. These people are supposed to ensure that matters before them are resolved impartially. You understand? So that no party will tag you as being biased and all of that. Right. But here is the case with this ruling. It has thrown us into more confusion. But the Supreme Court is actually supposed to rule on matters that everybody will look at it and say that no, this is actually the best way to go. But here is the case. They made all of us very confused in the House. Justice, why is it that in the 7th Parliament, issues like this never came up? This standing orders, we've been practicing it for how many years today? And why has anyone never ruled on such a thing?
But if you listen to the arguments of the Attorney General on behalf of the state, one of the things he sought to argue about is about the fact that the Constitution hasn't provided expressly, a provision that stops or barred the Deputy Speaker from voting on the floor of Parliament. Which article in the Constitution bars the Deputy Speaker of Parliament? It did.
Justice, let me tell you something. If you go to, it's the same. If you go to look at Article 104 and Article 102, the Article 104 talks about a member presiding and then having and voting. You understand? Now, even at the committee level, chairmen of committees do not have original votes.
I see.
Why did the Constitution say that? You understand? So the Supreme Court should have equally strike out that. Because if I'm a chairman of a committee, I represent my constituents. So at the committee level, you cannot tell me not to vote. The Supreme Court should have equally strike out that. You understand? You see, Justice, they have put us in more confusion, and I can see Parliament, the consensus that we are talking about, I don't foresee it. I don't foresee it anytime soon. Because if you listen to the minority leader and all of us, including people who are not politicians and all of that, you will get to realize that we are not going to cooperate with the majority side of government. Because we are looking at it that the Supreme Court is siding with the government of the day to destroy our democracy or our parliamentary democracy. That is what I can confidently say on this your show. I see. And I am very much worried, and many Ghanaians should be worried about it. This is not how we should run this country. This is not how our judiciary should operate. And you see, that is why, and let me also say that the judiciary, they do this and don't expect anybody to criticize them. Please, let me say that you are paid by the taxpayers' money. If you don't do anything right, we will criticize you. Is it like any other worker of this country? When you don't do your work right, people will criticize you.
What has the judiciary done wrong in terms of this? Because the Attorney General, actually espoused certain arguments of which the judiciary thinks that, well, those arguments are valid. They sided with him. One of those arguments had to do with forming a quorum, and he argued that the quorum in Parliament formed under Article 102 is different from the quorum formed under Article 104 of the 1992 Constitution. He stated that the quorum under Article 102 is for the conduct of business in Parliament, and that is why Article 102 provides that it should be 1/3 of members. Given that Parliament presently is made up of 275 members, the quorum under Article 102 for the conduct of its business is 92 MPs the AG submitted. According to the AG, based on the clear provision of Article 102, any person presiding, either the Speaker or the Deputy Speaker, is precluded from being part of the quorum.
Justice.
But that was different from the quorum formed under Article 104, which allows the Deputy Speaker being part of the quorum and subsequently voting. What are your disagreements with this argument?
Justice. You see, the manner in which the judiciary wants us to run parliament is neither here nor there. Justice, the deputy speakers are sitting in place of the speaker. You understand? The deputy speakers, when you sit or when you are presiding, you are clouded with the powers of the speaker.
Okay.
Decisions that you preside over are binding. The speaker cannot come and reverse them. You understand? Now, I am surprised honestly about this decision because one, we are trying to say that deputy speakers are not speakers. That is what we want to say. That is what we want to say, and that is totally wrong. That is totally wrong. Decisions that are taken in this country by deputy speakers are binding. So, let me just tell you, like the minority leader said, what is the difference between the Honorable Joe Osu presiding and the Honorable Asiema presiding? How is it different from when the speaker himself is president? Is there any difference? I want to know. I'm asking the judiciary. I want to know. Is there any difference when the speaker is sitting on the chair presiding and when the deputy speaker is sitting and presiding? Is there any difference?
So do you also believe that this, decision is politically motivated?
This decision, honestly, I don't know how to describe it. But for me, we leave it to posterity.
Do you think that this is to support, to affirm the collection of the e-levy, the approval of the e-levy, just as the minority leader has said?
I can affirm to what the minority leader said, that they are just finding ways and means to give government their way as far as the e-levy is concerned. But that is not the way to go, because one, we are still standing by our 137. That is not the way to build consensus, like I said.
Right.
But Justice, my questions are not answered, and I don't know who will answer my questions.
Right.
I'm simply asking that when the speaker is presiding, is it different from when the deputy speaker is presiding? Somebody should be able to tell me the difference. And whether when the speaker is presiding, decisions that he takes is different when the deputy speakers are presiding, any of them. They are all the same. They are all the same. You look, the other difference is that deputy speakers, by our standing orders and the constitution of this country, they are clouded with the powers of the speaker to sit and preside. So you cannot be sitting and presiding and still expect that you will go and vote. What of the chairman of the committee who is not having an original vote?
Right.
Why didn't the Supreme Court talk about it? You understand?
Very
so
well.
I'm simply trying to say that this decision that has been taken is an affront to our parliamentary democracy. It is something that we should all frown against. And I'm surprised that we have the president as a lawyer and all these things are happening. Tomorrow, Nanado will not be president forever. You understand?
Right.
And when you are taking decisions like this, these decisions are going to be binding on other rulings that will come or other cases that will appear before the Supreme Court. They are going to be used as yardstick or examples. You understand? So you cannot, when you are taking the decision, even if your hands are tied, even if you think that there is some amount of political influence on you to take such decision, but you ought to be careful, because they are the people that we are looking at to determine cases that will eliminate all manner of confusion in this country. But here is the case, like I said, this ruling has put all of us in more confusion than
has
before.
Created more
and
confusion
that is not what we expect of them. Now, Justice, the bench, I have always maintained that, look, I'm a member of the Judiciary Committee. We have met at several fora. We've met the Supreme Court judges in many meetings, And I have stated that, look, Justice, if we want this country to move forward, we should revisit our constitution. I have been saying it here.
Right.
The constitution has so many loopholes that people exploit. Just like what Godfrey Dami did, which is being affirmed by the Supreme Court judges. Look, I even have a problem with our judges being appointed. And I've told them in our meeting, I've said that you are a law student. If you finish law school and want to be a judge, go and join the AG department so that you can climb through the ladder to be a judge. Not that you see somebody on campaign platforms or writing articles against another political party, and based on that, you are qualified to be appointed to be a judge. Please, we have to be serious in this country. We have to be serious with our democracy. We are joking. It will collapse on all of us one day.
Do you agree with your... I'll come to you briefly because you...
We should not be joking. We should not be joking with these.
But do you agree with one of your colleagues who has actually said that any judge who turned himself a political judge will be treated as a politician?
Oh, but when he said it, he said any. So if you know you are one, stop. You understand? It was a conditional statement the Honorable Francis Xavier Sassoon made. Yet the Ghana Bar Association, everybody is on him. Please, we are not afraid of anything in this country. We are not afraid. We should all be careful about what we do. You cannot be putting pepper in my eyes and expect that I shouldn't cry. I will cry. I will cry. We are watching everybody in this country.
Right.
What did he say? What did he say? If you know you are not a political judge, why would you be worried? If they are talking about witches and I'm not a witch, why should I be worried? I don't have to be worried. But because some of them are victims, then they run to the Ghana Bar Association to discipline the young lawyer, which is bad. The Ghana Bar Association should not be used. They shouldn't allow themselves to be used by government of the day to be victimizing people who want to criticize the system constructively.
Right.
I am simply saying that they are not above criticism. They can be criticized because they are being paid by the taxpayers' money.
They are being paid by the taxpayers' money. Now let me go to lawyer Osman Al-Hassan on the decision. But first and foremost, lawyer, are you part of the new association? They said some group of lawyers have formed an association aside the Ghana Bar Association. I don't know if you have heard of that. Are you part of this new association we're talking about?
No, I'm hearing it for the first time.
Oh, I see. I'll show you the article and I think the registration of the association and all of that after the show. But, I mean, you've read the ruling. You've listened to the argument emanating from the quarters of the Attorney General. What do you make of it?
Let me first correct this impression. I have not read the ruling.
Okay, well, that's true. We've read articles.
Yes, I have read excerpts from the media, social media.
Right.
About what the judges have said. I think three main points.
Yes.
That the Deputy Speaker can count himself as part of the quorum.
That's right.
When he's presiding.
Exactly.
Second, he can cast a vote even when he's presiding.
Exactly.
And thirdly, that Order 109 of the Parliamentary Standing Orders is inconsistent with the Constitution.
With the Constitution, yes.
Void. I mean, this is what I got. And I was told they say the judgment is not ready. The reasoning for these judgments are not ready. And so they are not out there yet. So we don't know what reasoning has gone behind these rulings.
Exactly.
But if you look at each of these decisions, I mean, I will give the Supreme Court some benefit of that, pending the outcome, pending the publication of the reasons.
Yes.
But, I mean, if you look at the Constitution clearly, you know, let me clarify this. Interpretation of the Constitution is what the Constitution confers on the Supreme Court.
Right.
Exclusively. But we must understand what interpretation means. Interpretation is different from legislation. an interpretation of the Constitution or any power of the Constitution to interpret the Constitution does not impliedly or even expressly confer the power on the Supreme Court to change the Constitution, because there's a way of amending the Constitution. And so when you are making an interpretation, purposive or otherwise, in fact, the Supreme Court has adopted for itself what we call the modern purposive approach to interpretation. The modern purposive approach to interpretation, with due respect to many members of the Supreme Court, they need to understand it. Modern purposive interpretation, you know, when you are interpreting a constitution or a law, you first look at the black and white writings, because you credit the country. If it's a constitution, you credit the country, you credit the members of parliament, you credit the consultative assembly, you credit all the people who play active role in bringing the constitution to birth, with some reason, with some consideration of social undertones before crystallizing the words. So your first source of meaning for the Constitution is the words in the Constitution.
Right.
And that is what modern purposive approach to Constitution means. Now, when the words, the black and white you see in the Constitution, leads to an absurdity, then you now obtain the warrant to depart from the literal meaning, the ordinary meaning of the words, to now look into something else beyond the words, to look for the purpose, the intention of the maker. But where the ordinary words are clear, you don't go anywhere. Now, let's look at 102. Forget about quorum now.
Okay.
But we are looking at whether the speaker or the deputy speaker can count himself as a member of a quorum.
Right.
Now, if you want to know that, in express terms, it's in 102. Now, if you look at 102, it says apart from the person presiding, and listen carefully, it didn't say apart from the speaker. It said apart from the person presiding. And before then, the Constitution has clearly made it clear that both the speaker and someone else who deputizes him can preside. He said, in the absence of the speaker, the deputy can preside. Now, it comes down and says that apart from the one presiding, the quorum of parliament should be 1/3 of all members of parliament.
Exactly.
Now, forget about the part that is talking about 1/3, because in the same constitution, in respect of different matters, we have different quorum. Okay? When you are passing a legislation into a law and it gets to a point where it goes to the president and the president returns it for any reason, they said if Parliament passes a resolution after considering whatever amendment or whatever consideration the president has given them, and the resolution is passed by 2/3. Now I'm referring to Article 106. 106. Now, it said 2/3. So 102 said 1/3. 104 said 1/2. Now this is so in respect of different matters, we have different, different quorum to deal with.
Right.
But I'm not talking about quorum. I'm talking about whether the person presiding in Parliament over whatever quorum, whether it is the 1/3 quorum, whether it is the 2/3 quorum, or whether it is the 1/2 quorum, whoever is presiding over that quorum for whatever business, it should not be part of that quorum. Now, if you say anything other than that, you'll be saying that, okay, the general quorum provided in 102, whoever is presiding over that quorum, anytime Parliament is sitting and all the members are 1/3 of the total, then only in that instance will the person presiding will not be part of the quorum. In all other instances, the person presiding should be. I mean, it doesn't make sense. Do you get what I'm saying?
I get it. But
there's an absurdity there.
Yes, but I want us to look at 104.
When Parliament is sitting and they are 1/3 of their total number, then whoever is presiding is not part of that quorum. But in any other instance, he is part of the quorum.
He's part of a quorum. Do
you get it?
I understand the point you're making.
102 is talking about who should be part of the quorum, or is answering the question whether the person presiding, whether speaker, deputy speaker, first deputy, second deputy, whoever is presiding, whether that person should be part of quorum. If we want to know that, then we go to Article 102.
102.
And once it is expressed, when the Constitution is clear about it, there's no need for interpretation. Interpretation is needed when the words in the Constitution are not clear. Now, I'm dealing with the first point, the first decision that a deputy speaker, because he is a member of Parliament, he can count himself as a Now, but let me also say this. Even the speaker can be a member of Parliament. Check Article 95.
Okay.
He said the speaker shall be elected from among members of Parliament or outside members of Parliament. 95.
So a speaker could be elected from Parliament?
Yes. From among members of Parliament or from among people who qualify to be members of Parliament or something of the sort. But the point is that if this decision should hold any water.
Okay, so briefly, 95(1) says there shall be a Speaker of Parliament who shall be elected by the members of Parliament from among persons who are members of Parliament,
yes,
or who are qualified to be elected as members of Parliament.
Correct. So anytime we ever have a speaker who is elected from among members of Parliament, he will be voting. Do you understand that?
Right.
He will be voting, he will be counting himself as part of the quorum. Does that make sense?
It doesn't at all.
That's an absurdity.
So how then would Article 104 be really interpreted?
No,
where
Article
it says
104 is being used as a conduit of confusion.
Okay.
Article 104 is talking about determining a matter by voting. Okay?
Yeah.
But we are looking at where in the Constitution we can find an answer to the question whether the person presiding in Parliament can count himself as part of the quorum or vote. And I'm saying, if you want to find that, you go to Article 102.
Okay.
And that, to say that the person, the presiding member in 102 is limited to only 1/3 of the quorum because 1/3 is mentioned in 102 is absurd. It has to be interpreted reasonably to cover every quorum of Parliament. Every quorum of Parliament. If you are presiding over any quorum of Parliament, you should not be counted
part of the quorum.
Part of that quorum. But if this decision, as we have heard about, is actually true, then it means the speaker one day will also be voting. But let me tell you this. You see, the law is not in vacuum. We lawyers, we like Latin a lot.
Very well.
It's not in vacuum.
Yeah.
Okay? Law should always be seen in the context of society, in the context of a higher principle, in the context of a higher norm, which resonate with universal reason. Okay? Now, why would any law say that the speaker or anybody presiding over business in Parliament should not be part of the quorum for the business, for that business, or vote? Why? Because we have a law, a principle of natural justice we call nemo judax in causa sua, that you cannot be a judge
in your own court.
In your own court.
Yes.
All right? Now, why? This is a basic principle of natural justice, which if it is violated in any instance, even by a court, the judgment of that court is deemed to be void and has no effect. It's just like failing to give you a hearing. These are basic principles. And so, if the person presiding, it is the same person who is given the power to put the question to vote. Right?
Right.
Now, if you are presiding, what is your role? You are the one putting the question. And you have the discretion to even withhold the question. Before they vote, you will have to put the question. Now, if you have a side to the question that you are putting to vote, and then you say, okay, this is let's vote on this. Now, people have debated before the voting. Now, you pretended at the time to be a neutral arbiter regulating the debate.
Right.
And when it comes to voting, then you suddenly get into a side and consider yourself as any ordinary member of parliament, and then you vote for one side. Then why are you presiding? So for me, let's see what the Supreme Court brings out. But to be honest with you, and I have written time and again, I have written a lot about the way our Supreme Court is becoming. The way our Supreme Court is becoming. And you see, I really don't care much what others say, because you see, this country belongs to all of us. If we consider the way the Supreme Court, why is it that? And I'm not saying, and I'm not by this suggesting that the Supreme Court is necessarily biased. But what else can someone infer from a situation where a Supreme Court has never given judgment against government? Never.
They can't.
No. Why? That any time that government is involved in a matter and it gets to the Supreme Court, the outcome is so predictable.
Isn't the case that the Attorney General is able to advance, very, very cogent arguments?
Why? When the Attorney General went outside this country, did he bring a judgment? Is it not the same Attorney General who went and represented us in that our international case? Right? We have had judgment debts which were determined by courts outside this country. And it was this Attorney General who went there. How come that he didn't bring? And how come that any other... Why? Godfrey Dami is not the best lawyer in this country.
True.
Yes. And it is not also about the lawyer. It is about what he's saying. And it is not about knowing law. It's about reason. Because you see, a good law must resonate with reason. And everybody has reason. And that is why sometimes when it flies in the face of reason, you see a flurry of gesture from the populace. And remember, Article 25 is saying justice belongs to the people. Justice emanates from the people and is just being administered by the judiciary. Now, if you say it is emanating from the people and what you administer becomes foreign to them, are you administering what is emanating from them? Their concept of justice, their concept of, so for me, I'm coming back to the point of interpretation. To interpret a law, they have ended up amending the Constitution and mutilating the Constitution by piecemeal. You remember this case where a Supreme Court, look, they can say totally, completely what is not in the Constitution, and it suddenly becomes part of the Constitution. When it comes to this case about removing justices of the superior courts. And where prima facie cases has to be determined. There's no express provision with regards to the prima facie determination, or which body determines prima facie determination.
True.
In terms of the precedent, in the case of the Chief Justice. Okay? But the Supreme Court brought in words completely, totally different, totally absent in the Constitution. And that constitutes amendment to the Constitution. That cannot be interpretation. Interpretation must be limited to the words and meaning. Okay? And as far as you can go, you cannot go beyond the boundaries of the words to bring in. The moment you do so, you are amending the Constitution. But as I said, the reasoning is not yet here. But what I have heard is what I am finding it difficult to understand or apprehend in the context of what I know as the law.
Right.
We all went through the same legal training, legal education.
Very
what
well.
makes the difference is political appointment. That one is a judge.
I agree.
Yes. And so it doesn't make someone, it doesn't give someone some heavenly wisdom that he can now become an oracle instead of an interpreter of the known words and known language that we know.
So do you think that, though there is
for me,
do you think that the Supreme Court erred?
Yes, I think so. Well, as I said, the reasoning will tell us. The reasoning will tell us. But for me, based on just the three decisions I have mentioned, first, that a deputy speaker, and you see, I also heard that they said the deputy speaker could do so because he is a member of parliament and he cannot be denied. He cannot be denied his right to exercise the vote as a member of parliament. And that's why I said, if they say this, then they probably have not looked at Article 95, where it is possible to have a speaker who is also elected from among
in that situation, if a speaker is elected among the members of parliament, is the person not supposed to resign for elections to be conducted in the person's constituency once the person becomes the speaker? Though the Constitution has not expressly or impliedly provided for that, but is that not what is supposed to be done?
Yes. So why? That's a good question. But why would the Constitution expect you to resign?
Okay.
Why?
Because they want you to be
because the Constitution contemplates that position requires you to be neutral, to be a neutral arbiter, because one of the major roles of the speaker in parliamentary business is for him to preside. And if the Constitution requires that you resign after being elected to the position of a speaker, if you were a member, then by parity of reason, can't we say the moment you also come up there from among the members to preside, then you relinquish your right to vote and to be counted as part of the quorum?
Right. Very well. Right, viewers, you are still watching Hot News right here on Pan-African Television with me, Justice Appiah. Keep your messages coming in. And those of you watching us on Facebook, can share the Facebook Live for the people to also watch tonight's edition of the program. So I kindly give me 10 minutes to wrap up properly. Let me come to you, Honorable. I mean, I'll give you 5 minutes to wrap up. Honorable, so
yes,
you have 5 minutes.
Yes, Justice, let me come back to say that I honestly, our democracy, where it is heading towards, all of us have to be worried about it. And I think that the bench, the apex court of the land, they are the people that should help us in shaping our democracy, especially when there is confusion as far as interpretation of our laws are concerned. But like I said, I believe they have put us into more confusion. And let me also add that they should not try. You see, you do not, when you have political power, you don't use state institutions, suppose independent state institutions, to gag the others from functioning. When you do that and the table turns, then you because the reality is that no government can be in power in perpetuity. You understand?
Right.
There will be a time that the MPP will not be in power, and that time is very close. So if you think that today you are in power, you are in charge, then you can use your influence to amend or get certain rulings to gag the other arm of government from functioning. If tomorrow the table turns, how do you come back to overturn such decisions? Is going to be difficult. You understand?
Right.
Justice, let me also add that there are many Ghanaians who are losing hope and confidence in our judicial system. I will say it without fear or favor. If you go, there are many people, Ghanaians, there are many Ghanaians who the moment they mention court, they are panicking. He believes that somebody will go and influence somebody over him. You understand? And I think that our judges, especially at the highest court, they need to, I'm sure they are hearing all these things. They know. If you are a media person, take the cameras around and find out. You will get a very good percentage of Ghanaians who do not want to appear in court, even if he has a genuine case. I am telling you. They don't want to appear in court because they are losing confidence. He knows that when I go to a court, if I go to court with justice who probably is so connected to government or some powers that I will lose a case. However, genuine case that I have. You understand? And I think that we have to be worried about these things. These sentiments are being expressed every day. Like I said, when the member of the Honorable MP for Salga North, or is it South, the Honorable Abdallah, he made a statement about bottlenecks in our judicial delivery system and all of that. Many members contributed, and they came out with all manner of tricks that are being used in the judiciary system to outwit others, which is not the law. You understand? Being smart is not the law. The law is very clear. Let's all go by the law. The Constitution is very clear. Let's do it, to ensure that there is peace and sanity in the country. Let us don't use our powers, especially the court system. Let's don't use the court to gag others or to suppress others. We should not run this country like that, because the tables will one day turn. That is why I am worried that, and I want to repeat that, like my brother who is a lawyer, like your case, I've maintained that lawyers should not be appointed. I have maintained that lawyers should not be appointed. People who completed the law school, if they want to be judges, they should go into that system. The system should, there should be a system for them to follow and climb to the ladder to be judges. Not that today Justice is a law student, Justice sympathize with the MPP, and tomorrow when MPP is in power, then they say, let's recommend Justice to be appointed as a judge. Justice sitting on the bench will, in a way, try to favor his party. That is what we are condemning. That is what, when we talk, then people will say that we are attacking or denigrating the judges. That should not be the case. The Ghana Bar Association, they should be that independent. They should not allow anybody to influence them, because the table is always turned. Today, what is going to happen is that they are going to have a split, just like NAT and just like how NAGRAT and other bodies broke away from that. That is what is going to happen to Ghana Bar Association in the near future, based on the decisions they are taking today. So they ought to be very careful. Some of these things, they are the ones that should even come out to at least condemn and criticize the judges themselves. That is many years ago. Professors, lecturers, independent voices, they have always criticized decisions taken by the Supreme Court and other judges. You understand? But today, when you criticize a decision being taken by a judge, then they think that you are wrong. You have no right. No, that is where I always tell them, you are not above criticism. You can't be stopped from criticism.
Not at all.
You understand? You are a worker for the state. Anybody, not even the president is paid when he ate, or when he does things that the taxpayer think that he is wrong. They go after him. MPs, they come hard on us. Why do you think that when you err, in my opinion, I should not criticize you? Please, they should stop that. Nobody is afraid of them.
Right.
We will continue to criticize them. If they want, they should jail all of us.
All right. Thank you so much, Honorable, for your submission. Now, lawyer, you have 5 minutes, but my question is, if you look at the judiciary and the legislature, they are all, you know, equal branches of government. This decision by the Supreme Court, is it not one that is directing the legislature, parliament, on how to conduct their business?
Okay. In respect of that, as I said, the reasons have not come. But let me first make this. You see, the Supreme Court's powers have prescribed ways of invoking them. Now, Article 2 says, if any person alleges that another person's conduct is inconsistent with any provision of the Constitution, or that any enactment, listen, so you have to allege that someone's conduct is inconsistent, or an enactment is inconsistent with a provision of the Constitution. That person must apply to the Supreme Court. He said, you have to apply to the Supreme Court for a declaration to that effect. And when the Supreme Court declares, then the Supreme Court makes consequential orders to remedy the situation.
Right.
Now, so I don't know the kind of case that was presented to the Supreme Court. Whether the jurisdiction to strike down a legislation or an enactment was actually invoked. Because if I take your conduct, we have seen a lot of instances where the Supreme Court refused to interpret provisions of the Constitution, even though a matter is pending before them and calls for some interpretation of the Constitution, because their jurisdiction is not properly invoked. So it means you have to issue a writ with respect to that conduct, and then you depose to facts that you rely on, and you now ask for the declaration that this man's conduct is inconsistent with the Constitution. Or if you want interpretation of the Constitution, you ask that before they can now exercise that jurisdiction to interpret. But you can see that it appears there was a need for interpretation of Article 104. That's why I said I can't say it with certainty, but because I don't know the
reasoning,
the case that
that was presented. Yeah.
But I am suspicious that their jurisdiction to strike down a legislation was not invoked. That an allegation that Order 109 of the Parliamentary Standing Orders is inconsistent with a certain provision of the Constitution, and so we seek a declaration that it is so inconsistent. I don't think that was what was presented to the Supreme Court. And so if the case was about interpreting whether the Speaker or the Deputy Speaker could count himself as quorum or cast a vote while presiding, that is an interpretation of Article 102 and 104 that was required. Now, if someone goes to the Supreme Court with an issue of interpretation, I wonder if the Supreme Court can go beyond the interpretation to strike down a legislation which also is a different item of jurisdiction that must be invoked.
But just as you've said, I mean, per the article over here, then it means that the person who filed the case was asking the Supreme Court to interpret Article 102 and 104 of the 1992 Constitution.
Exactly. So how,
and declare the action of Osirius as unconstitutional.
How striking down of Order 109 of the Parliamentary Standing Orders became part of this still baffles my mind. Because I mean, you can't exercise a jurisdiction which is not invoked. Now, but let's assume let them come and tell us that, okay, well, they can do so, even though they have refused to interpret constitutional provisions in matters pending before them within other jurisdictions. For instance, if I invoke their supervisory jurisdiction to quash a certain order, and a constitutional provision is alleged to be unclear, they will not interpret it. They will say you have to go and issue a writ to invoke it. So how come that someone brings an issue of interpretation, assuming that they were presented with an issue of interpretation of Article 102 and 104? All right. How would you now extend your jurisdiction to go and strike down a legislation? Meanwhile, it is also an item of jurisdiction that it need be invoked separately with a writ, or at least alleged in the writ that is before you.
Right.
So let's assume that, okay, that was not done. But Parliament, we all know, by Article 110, has the powers, is conferred by the Constitution itself, to make rules or to regulate its own procedure.
Masters of their own rule.
But subject to the provisions of the Constitution.
Okay.
All right? And when a law or a provision of a law commence by saying subject to anything, it means everything in that provision is subservient to what it is subjecting it to.
Yeah.
So it means that Parliament can make rules to regulate their own procedure as long as those orders, standing orders, do not come into conflict with any provision of the Constitution.
Okay.
Or does not violate any provision of the Constitution. Right. So now if you struck it down, saying that it is inconsistent with a particular provision of the Constitution, then of course you have to tell us which provision of the Constitution
that is inconsistent with. Okay.
Justice, let me just chip in this. See, in addition
we have to go.
Yes, in addition to what the Supreme Court did, if I were the Honorable Joe Usu and then the Honorable Asiema, I will simply even resign. Because, let me tell you, members of Parliament will not accord them any respect. Because we are all now the same. They are now like ordinary MPs. If they are coming, I can decide to sit. I won't accord you that respect. You understand? You know, that is what they have done to them. They've damaged that office. That ruling has damaged the office. People will not. That was when, you remember, before Christmas, when he was to give one of this ruling.
We have to get going.
He said that I am not the speaker.
The speaker.
And that was when somebody said, if you are not the speaker, you cannot sit. Leave the seat. You understand? That is the problem. You see, there's going to be more confusion in Parliament in the coming days, and that is my worry. And caused by the Supreme Court, that should know better.
We can't wait to see such confusions. No, you have a final thing to say.
I wanted to tell the public what actually Order 109 is saying.
Very well.
109 is simply saying that there should be a secret voting if it has to do with an amendment of the Constitution. If they are dealing with a bill that is to amend the Constitution, there must be a secret voting. That's what I see in Order 109.
Right.
And then that if they are voting, passing a resolution to remove an occupant of an office, a constitutional office,
right,
person who occupies an office under the Constitution, then there must be a secret voting.
Yeah.
So it means that Parliament is saying wherever we have the authority to vote, the power to vote in these matters, that vote must be secret. And that is the procedure they have prescribed for themselves. So how can the secret voting be unconstitutional? And as I said, until we see the reason, Definitely the Supreme Court will tell us.
I think that when the reasoning we'll come here again. This is what time will allow us on the program. Make a time with us. Same time tomorrow. My name is Justice Appiah, and the show has been Hot News. I've been doing this with Member of Parliament for Drapa constituency, Honorable Cletus Seydou Dapila, and then also lawyer Osman Al Hassan, who is a private legal practitioner. Goodbye.